The only thing necessary for the triumph of evil is for good men to do nothing. Ladies and gentlemen, we stand today not to beg, but to demand what is already ours by birth, by law, and by human dignity. Our rights, our families, and our voices. Across this nation, and indeed around the world, parents and children are being systematically violated by institutions that were created to protect them. Family courts, child welfare agencies, and local governments. Instead of defending the family, these institutions have weaponized custody, silenced due process, and institutionalized abuse. Cities, states, and counties have erected a treasonous structure of governance, one that overrides our Constitution through arbitration, mediation, and judicial discretion, bypassing the rule of law and replacing it with subjective power, unchecked by justice. These administrative proceedings masquerade as lawful courts, but in truth, they operate outside the constitutional Article 3 judiciary, violating both state and federal law. By denying parents due process and stripping children from loving homes without proper hearings or constitutional safeguards, these governments have betrayed the very soul of our republic. In doing so, they have formed unlawful confederacies, arbitrary governments that commit treason against the supreme law of the land, the U.S. Constitution. The offenses committed by these institutions transcend national law and violate universal human rights as recognized globally. Universal Declaration of Human Rights, UDHR, Article 1. All human beings are born free and equal in dignity and rights. Article 16.3. The family is the natural and fundamental group, unit of society, and is entitled to protection by society and the state. International Covenant on Civil and Political Rights, ICCPR, Article 17. No one shall be subjected to arbitrary or unlawful interference with his family. Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment. Article 1. Defines torture as any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted by or with the consent of a public official for purposes such as punishment, intimidation, or coercion. Article 2, Clause 2. No exceptional circumstances whatsoever may be invoked as a justification of torture. These institutions have used coercion to force parents into mediation and settlement, threats to compel silence and compliance, fabrication of evidence, and strategic placement of children into the hands of known abusers, all of which amount to psychological and physical torture. Let us be clear. When governments knowingly place children into the custody of abusers, when they falsify records, when they deny hearings, and launder federal funds through Title 4D and Title 4E incentives, they commit fraud, they conspire, and they traffic in human lives. This is not negligence. It is intentional. It is systemic, and it is criminal. They will be held accountable. We declare now no more. Every city council, every county agency, every state department that engages in this systemic violation will be charged and held accountable. Under federal law for civil rights violations, 42 U.S.C. 1983, RICO violations, and deprivation of rights under color of law. Under international law, through complaints filed with the United Nations Human Rights Council, the International Criminal Court, and under the Convention Against Torture. We are assembling the record. This is not just a speech. It is a notice of liability, a call to action, and a record of declaration. We are compiling testimonies, filing legal petitions, reporting violations, and organizing a united movement to dismantle the family court industrial complex and prosecute those responsible. The days of silence are over. The age of justice has begun.